So the PTPA, the Professional Tennis Players Association, is a relatively new organization that was set up by a number of well-known players, including Novak Djokovic. And as you said, it's not an officially recognized players' union, but it has been advocating vocally for the interests of professional players for some time now. It's just that it hasn't reached any form of collective agreement with the governing bodies of the sport to sort of cement its place within the governance framework of the sport. And obviously the governance framework of tennis is sort of split between the various different governing bodies. We have the ITF, which is the International Federation. We have the ATP, which is the governing body for the men's tour, the WTA for the women's tour. And then there's the ITIA, which deals with integrity issues. Interestingly, the ATP and the WTA were really initially set up as associations of tennis players. I mean, that's what the ATP stands for, Association of Tennis Players. The WTA is the Women's Tennis Association. So they were very much set up as player associations, but then they have evolved over the years into being effectively governing bodies. And so the members of those organizations are both the players and the tournaments that the players play in. So in a sense, there is a player voice well established within the governance of professional tennis, but that voice is sort of a part of the governing bodies these days. There isn't sort of an independent group. Until the PTPA was created, there wasn't an independent group advocating for their interests externally. So that's sort of where the PTPA fits into all of this. In terms of whether they might become an officially recognized union, there's not exactly an official or established process for this. And the main reason I say that is because, of course, tennis players are independent contractors. They're not employed in the professional sport. They're not employed by clubs, for example, in contrast to footballers or rugby players, for example. And therefore, the tennis players don't necessarily, and their associations don't necessarily fall within the sort of traditional labor law frameworks for collective bargaining, which are targeted at employees or workers. So there's not exactly a formal legal process, as far as I'm aware, that they would go through to achieve that sort of official status. Really, it's a question of negotiation. And so I think we'll probably come on to this later on, but I think really this whole case, the lawsuits, the complaints that have been made, probably form part of what they hope is a process towards becoming more officially recognized within that governance framework.
Which I'm sure, therefore, a lot of people, if not everyone here, will have had some understanding already of what the case involves. And broadly speaking, the PTPA allege anti-competitive practices by the governing bodies, which are causing harm to players. And the PTPA lists these out all separately, but I think they can be grouped relatively well into three broad areas, really. So I'd call them the pure financial aspects of the claim, as part one, the scheduling aspects as part two, and the welfare aspects as part three. And so this is something that I think is an easy way to frame it. It's not how the PTPA has framed it itself. As I say, they've listed out individual issues in turn, but using that framework, the pure financial side is really three things. The first being the fixing of prize money. So tennis players make their money through prize money and through sponsorship. They're not employees, as mentioned earlier. They're independent contractors, and so a key aspect of their finances, if you will, is prize money. And there are regulations within both the ATP and WTA tours that fix the amount of prize money that each tournament may award to the players, what for both for winning, second, winning the quarterfinals, etc. And the PTPA's claim is that this is fixed in a manner that prevents tournaments from competing with each other. Like, it's anti-competitive, and that if this wasn't in place, then the prize money available to players would have increased through tournaments, offering more and more prize money to attract the best players. Secondly, and looking at that sponsorship angle we just mentioned, that as part of this pure financial aspect of the complaint, they are alleging that sponsorship opportunities have been restricted by the governing bodies. So players are restricted in the sponsorship that they may obtain outside of that which is obtained by the tours on their behalf. And thirdly, there's an exploitation of name, image, and likeness rights complaint in there as well. A complaint that those rights have been exploited by the governing bodies without proper compensation to the players for that. So those are sort of the pure financial aspects of the complaints. And then the scheduling aspects, which we said was sort of being part two. There's two real arms to it. First, the unsustainable schedule, I believe is how they phrase it. They speak of the schedule lasting 11 months, being too much for players. Players are required to compete with very short break periods between competitions. And they also speak of the schedule being fixed on players, and players therefore being prevented from playing in non-sanctioned events, playing in events that aren't ATP and WTA and Grand Slam events, due to the fact that they have to take part in a rigid and clear schedule of sanctioned events. So that would be another area where they're saying that competition is restricted. Players can't go and offer their services to somebody else. They are tied to offering their services to the ATP, the WTA, the Grand Slams, etc. And then the welfare aspect as well, that links into the scheduling that we've just mentioned in terms of the busy schedule, and it also overlaps into comments on match conditions that are mentioned. There's references in the complaint to matches often running to times like 3 a.m. in the night, or having to be played in excessively hot conditions, and that's another element of the complaint as well. And then separately, and this is where the ITIA, the investigatory body, comes into it. They are asserting that the powers afforded to the ITIA in terms of its investigation of corruption and anti-doping offences are, or they violate fundamental rights. They violate a right to privacy through phone searches. They involve anti-doping testing late at night. So it's disruptive to players' schedules. So broadly speaking, there are those three areas: the financial, the scheduling, and the welfare. But you can see running through them that there's overlaps with the various claims. The welfare claims overlap into the schedule, and the scheduling issues are a huge part of the financial issues that are being asserted. And in that regard, this is not the first time that scheduling concerns and financial concerns have been raised in professional tennis. This is just obviously a claim that is bringing together a number of those issues at once in multiple jurisdictions.
I think the starting point is that as far as I'm aware, there's not currently a rival tour, unlike in the golf example where Liv came along. In football, obviously the Super League came along. So we don't necessarily have sort of a direct rival. I'm not sure that makes a huge amount of difference, because whilst the governing bodies might say, "Oh, look, we're not stopping them from going anywhere else. There simply isn't anywhere else," the players might say, "Well, there isn't anywhere else for them to go because there is such a major monopoly within tennis." But this is effectively the dispute that has arisen in golf and football, as you've highlighted. I think generally speaking, and again, this is not from a US law perspective, but generally as sort of a principle of competition law, it seems unlikely to be lawful for the tennis tours to impose absolute bans on play or impose absolute restrictions on players participating in other events so that they can't do anything, but it's probably legitimate for them to impose some limits on when and how they can do that, in order to ensure the effective organization of the sport, or you know, of their competitions. And I think it's worth probably just sort of turning to what the rules currently say about this. The WTA rules, for example, require players to play in WTA 1000 events or WTA finals events if they qualify, and at least 6 WTA 500 events a year. Then in the men's game, the ATP rules require the top 30 players to play in all Masters 1000 events, ATP finals, and then 5 ATP Tour 500 events. Whilst other players are then restricted from playing in, you know, unsanctioned events, non-ATP events, in the weeks of all of those tournaments, as well as all ATP 500 and Grand Slam events. So effectively, the rules in the women's sport require players to be at certain events. In the men's sport, they require the top 30 to be at certain events, and then stop everybody else from playing, you know, most of the rest of the time. And the point there is that there are a lot of these events, and so therefore they take up a substantial part of the calendar, such that there isn't really room for these other competitions to take place, meaning there are limited opportunities for the players. And the other point to note in the ATP rules is that it goes beyond just restricting players to, you know, from playing in other competitions when ATP competitions are on. The rules actually say that they cannot do so in events taking place 30 days before and 30 days after, or 30 days after the ATP or Grand Slam event within a 100-mile radius. So when you factor in the number of events, and then you factor in the fact that, you know, there's this window of 30 days before and after when you're not allowed to play in other types of events, that's going to be quite a substantial part of the year. And so that's really where the restriction comes in. And then there are fines and potentially even bans for breaching those rules. But of course, it must be legitimate for the tours to be able to ensure that their talent will turn up at least, you know, at least some of the talent is going to turn up at all of the events. Otherwise, it's going to be impossible for them to generate sponsorship revenue, get broadcast deals, etc., which is ultimately what allows each event to generate the funds to pay prize money and thus pay the players. So it is in the players' interest for there to be some form of structure, some form of sort of minimum requirement for them to participate. Otherwise, the tour just simply wouldn't work. So that's why I say it's going to be a question of reasonableness, proportionality. But I don't think at the other end of the spectrum that the tour could sort of stop them from participating in any other events. And I think that the Super League case sort of probably gives some guidance on how EU law and probably UK competition law, given their similarity, would deal with this, because of course that case was about sort of the authorization of new competitions, and the focus there is very much on the importance of there being objective, transparent, non-discriminatory and proportionate criteria for the authorization of such events. And so in this context, I think the question would be, well, if you know, what are the criteria that determine when a player will be allowed to go and play in another event? And I think adopting that similar approach is likely to be what EU law would say. I don't know whether US law takes exactly the same approach, but I imagine that it would be sort of broadly consistent with that idea.
And if I may, just to add something as well, that the complaint makes a number of references to the ranking system and the ranking points system that's in place. And so in addition to what Ben's very brilliantly covered in terms of the regulations on what you can and can't do whilst these competitions are going on, there is a suggestion from the complaint that players are very tied to sanctioned events, tied to ATP events and WTA tour events, because they need to pick up the ranking points that are going to bring them up the rankings, that are going to allow them to qualify for better or higher rated tournaments, and that are going to allow them to then have better draws to go further, to make more prize money, to increase their own brand and increase sponsorship. And so there is this system in place that operates somewhat to the benefit of the players, in terms of they will, if they do well, they will climb rankings, they will create a bigger personal brand, and they will make more money. But they are also framing it as anti-competitive, in the sense of they are forced to take part in this practice, forced to play in these events in order to grow their brand, because they won't be able to grow that brand elsewhere. They cannot themselves become a player that is going to easily be able to make it their way through Grand Slams or through Masters events without taking part in this structured 250s, 500s, etc. system that is in place already. So it sits both ways, because there needs to be, you can see that there probably should be, I should say, something in place that allows for this kind of progression, and that creates structure and offers, creates a system where there is a world number one and there is a world number two, and the organisers of events are able to sell to everyone, look, we've got the one versus the two here in our final this year. Somebody who is ranked outside of the top 10 has just beaten the world number one. These sorts of stories that people see and that make it into the national media, there needs to be the opportunities for a sport to be able to sell itself. So you can see that the ranking system that is alleged as anti-competitive will have some benefits as well, and there needs to be a balance in place to afford this structure, whilst also affording players an opportunity to make money and not be restricted in the offering of their services. I think at the outset it's a tricky one. It's not really a competition law issue in the same way that the other points we've discussed are. And it's for that reason that I think it would be surprising if that particular aspect of the claim succeeds here, because I would think that the focus is going to be on other issues that we've already discussed in some detail, and I would therefore think that this might not get the attention that actually it deserves. And in fact, maybe this is an issue which requires its own case, its own complaint, and thorough consideration by a tribunal specialised in considering these types of issues. And that's also in part because, as it comes to the anti-doping side of things, this would represent a challenge not just to the ITIA's processes, but in fact to the wider WADA anti-doping ecosystem. This idea of anytime testing, again, it's not quite any time, but of being available for testing anywhere, on any time, on any day, that's a fundamental part of the WADA code and the system that's in place there. And so the idea that a doping control officer can come at 6 a.m. in the morning to your house and wake you up and require you to give not just a urine sample but a blood sample, or they could do that at 10:30 in the evening, that comes from the WADA code. So it would be surprising if a tribunal here, a judge here, chose to make comments on that in the context of this case. But it's definitely something that deserves its own attention as to where that sits in terms of violating athletes' rights to privacy and how fair that is on them. Of course, you mentioned the specificity of sports. You can also mention the fact that athletes ultimately are consenting to this by taking part in sports that have this within their rules. One might say, well, they simply don't have to take part in a sport that does that, and you might say they need to go and consider the enhanced games or something like that if they want to avoid this kind of regulation. So it's an issue that I think we could discuss an entire other webinar sort of point around whether that's forced whether that is indeed consent, given that it's forced on them in order to compete, and what is fair and what isn't within those rules. I will, however, say that the phones, particular regulation around being able to investigate, take control of, and then scroll through athletes' phones, messages, etc. That's a very interesting one. It's part of the anti-corruption rules as well. And now, obviously, I would expect, although I'm not certain, that this will be addressed on a case-by-case basis as to whether, in that particular instance, there is justification to do so. But it is a point for further consideration. Again, outside, I think, of the scope of a competition law claim, whether that is appropriate, and whether, in the event that it is appropriate, it is exercised appropriately and reasonably, and respects athletes' rights at the same time. So, yeah, it's very, very, very interesting area that could be given a lot more attention.
Firstly, with the US litigation, the next step is this motion to dismiss that we mentioned earlier, which has been brought by the governing bodies, saying that the PTPA doesn't have standing, and also asserting that the players would be required to bring their claims, the ones that have been brought by players individually, through arbitration, because there are arbitration clauses in the WTA and ATP rules. So that's the next thing that's going to be considered in the US litigation. I'm not a US lawyer, I can't tell you how long that's going to take, but that will be the next thing to be decided. In the other complaints, the complaint that's been made to the UK competition authorities and the complaint that's been made to the EU Commission, those processes tend to be quite slow moving. It's something that could take many, many months. I expect that the CMA probably wouldn't reach a decision much before 18 months have passed since the complaint was made. So that's likely to be something that rolls on for some time yet. I think really where this is headed is probably going to be somewhat dependent on how the motion to dismiss plays out in the US. But I think really what the PTPA are looking for is likely to be some form of settlement, as we've alluded to earlier, because they're not currently recognized within the governance ecosystem. It seems to me, and I think Sam agrees, that this has likely, this whole case, all aspects of it have likely been brought as a very hard negotiating tactic. And they'll hope that they can effectively pressure the governing bodies into coming to the table with them, recognizing them as a union, and then acceding to some of their demands regarding playing schedule, prize money, etc. So I think that would be the PTPA's preferred route through this all. In fact, I know that to be the case because they've said it publicly. But I mean, there doesn't seem to be a huge amount of goodwill coming from the governing bodies side at this moment. And like I said, I think the motion to dismiss could be pivotal, because if that succeeds and effectively the claim is kicked out, or the PTPA's claim is kicked out in the US, then that really, puts the PTPA in a fairly weak position. The players could presumably continue their claims through arbitration, and presumably the PTPA would financially back those claims, but it's going to be a lot harder for them, for the organization, to sort of force a seat at the table. On the other hand, if the PTPA succeeds in defending the motion to dismiss, then the governing bodies will be faced with the prospect of this having to go all the way to trial in the US, forgetting for a moment about the UK and EU complaints, which could still go somewhere. And that might well be enough for them to think about reaching some form of settlement, or at least starting those sorts of conversations. So that's sort of a little bit of a feeling that we have as to where it might go. In terms of what we've seen in other sports, I think the main example, well, no, there's two examples, aren't there? There's the golf and the MMA. I know that in golf, when the PGA Tour banned a load of players for joining LIV, they then filed antitrust lawsuits in the US. And in the end, that case was resolved by the Saudi Public Investment Fund, who backs LIV Golf, coming to some sort of agreement with the PGA Tour, as to the future governance of golf. That's effectively, I think, what the PTPA are hoping would happen here. And then in MMA, I think also that there were settlements which sort of compensated players, fighters, for sort of the suppression of their earnings in the past. So again, that's something that could happen if the PTPA is sort of able to force the claim all the way through. But I think really all eyes will be on what happens with the motion to dismiss in the next little while, although I can't tell you how long that little while will be.